say. So which one is the best one for me to look at, Mr. Verdict?
Your Honor, I received some additional red lines over the lunch hour. Um, if I might, as the court's scrivener, if you will, today, show you digitally those because I don't know how they track against the version previous for Mr. Carroll.
All right, yeah, if you want to share your screen, you're welcome to do that.
Thank you.
I'm assuming y'all want a record. Do you want a record of this?
Yes, Your Honor. So, Your Honor, I'm Charles Verdict for the record, here on behalf of petitioner Jessica Sabine Marie Monroe. Uh, if Mr. Carroll's not going to make his announcement, then I'll.
All right. Yes, Your Honor. Blair Carroll on behalf of respondent Benjamin Nicholas Monroe, and we're ready to proceed.
So, Your Honor, I've shared to the screen the order. There's two operative orders today. On March the 8th, we were set on a pretrial and discovery matter there. The court granted petitioner's motion for death penalty sanctions and rendered the divorce. So before the court, and I'm showing here, is first the order granting petitioner's motion for death penalty sanctions. I believe we're very close there. I'm scrolling to, I've accepted all changes. I'll alert Mr. Carroll that I added his prefix initial of R. His prior edits didn't have that, so there is that one edit. But where you see red lines or purple lines here, those purple lines are changes from Mr. Carroll that we wanted to get rulings on. Here on page 2 at the top, we have the enumerated violations. Mr. Monroe was ordered to provide supplements for request for production 25, together with interrogatories 14 and 15. You might recall that he didn't tender a supplement until the morning of trial. So in addition to that, interrogatory 14 and 15, which I have here to refresh the court, these were interrogatories that he was ordered to answer. They had numerous subparts, such as they had to do with his adultery, with whom, what did he spend, and where. And basically, he only answered the name with no subparts as to how much and when those were made. So we're asking that the court adopt that finding. We believe that these findings go to the pattern of discovery abuse.
So tell me, the stricken language is language he struck and that you want?
Yes,
So you're asking for a finding that he violated the order when he failed to produce documents responsive to request for protection 25 and answers to interrogatories 14 and 15.
affirmative.
All right, let me hear why it is that you think that shouldn't be included, Mr. Carroll.
Your Honor, I would just say that my understanding is that we did in fact produce that responses to request for production number 25, as well as the 14 and 15 of the written interrogatories. And there was no finding made on March 8th that this did in fact happen.
All right, let me hang on, I have too many things open on my screen now. So when did you produce the response to request for production 25 and the answers to interrogatories 14 and 15?
I don't have the date in front of me, but I do believe, Your Honor, that if according to Mr. Verdict, that it was the day of or the morning of, I guess, the 8th of March.
Your Honor, I do have the discovery instruments in front of me. The request for production supplemental request was dated March 8th, 2024, which was the day of. Likewise, the operative interrogatory was dated October 30th, 2023. October 30th, 2023. And I can refresh the court by permitting you to see the answer if you would like to refresh yourself.
Sure.
One moment. Here, Your Honor, I'm showing to the court the respondents' third supplemental answer to interrogatories that are dated October 30th, 2023. Answer 14, which goes towards adultery. The subparts are where you can quickly pick up identity and location, A, dates and times, locations, B, and where there's contact, sexual contact, lodging, meals, etc., the amount of the expenses, the date, and to whom it was paid.
All right,
So
this is the most complete version of the answers. These are the ones that were received on the day of the hearing.
So there's two questions there. These were not, the last question is what date were they received? No, these were received on October 30th, 2023. And these are, however, the most up-to-date answers to interrogatories. He had propounded another set of not propounded, but tendered another set of interrogatories after these that didn't include additional answers to 14 and 15.
All right, and so this is part of what your motion to compel on, was to compel more complete answers to 14 and 15.
Yes, Your Honor. And in fact, there were already orders out there ordering answers.
Remind me of the date of those orders.
In the language, and I'm bringing back up the proposed order because it contains that, Your Honor, one moment. I'm taking us back to the order that you were reviewing previously. You'll see it makes reference to the proposed order. So April 27th, 2023. I don't have that order up. I can get it.
Hang on, I can get it.
Subpart B, written interrogatories.
I see that. So I see there's an order of April 27th, 2023 that specifies that Mr. Monroe shall respond to interrogatories 14 and 15 fully. And what you've just shown me was not a full response, and you did not receive a more complete response after what you just showed me?
That is correct, Your Honor.
All right. And then request for production 25. Tell me about that one. I see it says video and audio tapes. Respondent shall produce documents responsive to this request by producing video and photographic evidence of his sexual and prurient pursuits during the marriage with persons other than his wife. So
Yes.
did he ever produce anything or propounded response that said there are none?
So here, Your Honor, I'm showing you the fourth supplemental response that was live and tendered to us the day of trial. And you'll see in the middle here 25 rather, response, see Mr. Monroe's verified response attached. He says the only responsive video in my possession was produced to Mr. Monroe, or excuse me, Miss Monroe, and I won't read it all, but here on, and it's averred on the 7th of March, 2024.
All right. And how is this response deficient?
Well, first, he had waited from April of 2023 until the day of trial to tender this answer. So this was presumptively stricken, untimely answer under 193.6. While I believe the court was aware on the day of trial of the interrogatory and the request for production, certainly that was discussed. This was not marked as an exhibit. Nowhere in the record of my recollection did you rely upon this untimely answer. And I'd have to go back now. It wasn't live. We weren't being interrogated about it, but I'd have to look at my records to see if in fact I did receive from counsel a video on June 28th, 2023. He says he's produced it to Miss Monroe. And I will do it just now. I'm going to my discovery index and
so I think that gives me sufficient information. So
I will let the court know I did not receive any. I received documents on 6/28/23. They were car documents. I'm looking directly at my discovery index. I can show that to the court. On 6/28/2023, I got a supplemental production that contains car documents.
Not
Your
necessarily.
Honor,
Hang on, Mr. Verdict, will you put that language back on the screen, please?
Yes, Your Honor, forgive me.
And I'm going to let the other folks in who are lined up waiting for their hearing, just so they can see where we are in this hearing.
Here you're asking to see the text of the proposed order, correct?
Right, right.
Okay.
And let me just say to the people who are here on Fuller, Zook, and Koenig, we are still on the Monroe case, which was supposed to start at 1:30, but started late. Mr. Beck, how much time do they have left?
I apologize, Judge, due to the nature of the back and forth, I haven't been keeping time.
Oh. Okay, well, let me ask Ms. Williamson, what time do we start?
Please hold, Judge. 1:50.
All right, so we've been going 15 minutes and we're going to go for about another 15 minutes. So the rest of you who aren't here on this Monroe hearing, if you'll just turn off your camera, that'll make it easier for us to figure out who's speaking in this hearing, and we'll get to you all as soon as we can. I'm going to ask Mr. Beck to put 10 minutes on the clock for Mr. Verdict and 15 on the clock for Mr. Carroll from here on. I know Mr. Verdict has spoken for at least 5 minutes. All right, Mr. Carroll, your response.
Your Honor, in response to number 25 in request for production, I would just state that Mr. Monroe did provide the only video evidence in his possession at that time. If I recall correctly, I was thinking that we had provided a hard copy of that video to Mr. Monroe due to the explicit nature of the video and not wanting to send that online.
So the problem, of course, is that the court had signed an order on April 27th of 2023 compelling various discovery responses, and the order specifies that the respondent shall produce the documents below within 45 days of the date of that order. So that order was April of 2023. So by mid-June of 2023, that should have been supplemented. And what Mr. Verdict is telling me is that the supplement didn't come until, didn't come by June.
That's correct, Your Honor.
It was
So-
October for the interrogatories and the day of trial, March 8th for the production.
And in that order of April 27th, 2023, the next to last paragraph says the court admonishes respondent that greater sanctions may be levied if he fails to timely and fully produce the documents ordered herein. So there's an order of almost a year ago that your client didn't comply with. And then there's another order, isn't there, Mr. Verdict?
Yes, that, Your Honor, is the second paragraph you'll see in the order that's before you. There was a second order of discovery compel on October 27th, 2023. At trial, we were dealing with all the issues, or not trial, but rather the death penalty sanctions hearing of the non-compliance around the phones, the plural phones.
Right. So actually, the hearing was October 27th, 2023. The order was November 8th of 2023. And so we've got two orders compelling, which is what caused me to grant the death penalty sanctions, is because your client had been admonished twice that these things needed to happen. And that's in number 7 on the October order. On page 5, it says the court admonishes respondent that sanctions may be levied if he fails to timely and fully produce the documents and answers to interrogatories ordered herein. And I think,
And I believe, Judge, that is correct about Mr. Monroe being admonished twice. I don't think there were any sanctions levied, though, prior to the ones on March 8th.
Well, there were attorney's fees.
Yes.
Those were the sanctions.
You're correct, Your Honor.
He told him to pay attorney's fees, and he was told you're going to get more sanctions if you don't comply.
Okay.
So the bottom line is, with respect to this language that's stricken in the top paragraph, I agree that should be included, and so you should reject those changes. All right, next.
The next is the October 27th order. He was ordered there. You were just exegeting over it. Production of his phones at trial on the death penalty sanction. The court found that he was late in sending his second device, and they acknowledged at the hearing that they were late. And then in addition to that, there was a third device that they claimed an argument that was lost. That was just argument. The evidence before the court was that it was the bill was that the number was active and being paid for. So these two strikes are an attempt to walk back the discovery noncompliance, respectfully, that in such a way to try to attack this perhaps on appeal or otherwise, that there aren't sufficient findings to support the bad acts. And we paid it.
I agree. So I'm going to agree that those changes should be rejected.
Understood. So on the divorce decree, if I can have the court's permission here, there's it's really a fundamental question, I think, which will resolve most of the controversy. I'm scrolling to page 2 of 17 on the section, Your Honor, which says division of marital estate. Recall at trial that the primary asset was Mr. Monroe's pension. He's a professional tennis player. The pleadings were struck. Your rough draft or your draft of your rendition is there before you. We didn't have the money to pay for that, but my unaided recollection is that you specifically awarded for that, the total of that pension, 70% to Miss Monroe, 30% to Mr. Monroe, likewise doing the same with the accounts that were before the court. And then finally, awarding various attorney's fees and unpaid spousal maintenance from and secured by Mr. Monroe's 30% in the pension and any cash accounts that had been enumerated throughout this. And I can just...
I'm going to read what I said in that hearing.
Yes, Your Honor.
It's just a rough draft, but it's, I believe, fairly accurate. I said, so I'm going to grant I said, this is the third hearing and it's time to grant death penalty sanctions. So I'm going to grant a default judgment against Mr. Monroe, striking his pleadings. I find that it is in the interest of justice and it conforms with Texas Rule of Civil Procedure 215. I'm going to award the items requested by Mr. Verdict. That is 70% of the assets we know of in the community. I'm going to award her the spousal support and attorney's fees requested, secured by Mr. Monroe's remaining community assets. I made a finding of adultery. And that was after you had explained, because I had asked you to thoroughly explain what you were claiming 70% of, or what you were asking me to grant to Miss Monroe 70% of. So that is what I ruled.
So the challenge here, and I'll wrap this up in 30 seconds, is they took that as a 70-30 net of all debts. And likewise, meaning Mr. Monroe, and likewise, they're trying to import a value on the pension and import new, what they claim are debt amounts that are debts in the name of Mr. Monroe, which you assigned to him. Two problems there. First, you didn't make a factual finding as to the value of the pension. You said 70-30 as of the date of the trial.
Right.
And in their proposal, they're trying to use 2022 values. This is a pension where you get an annual value. If you were to adopt that, it would reduce her award perhaps by almost 6 figures. So that fundamental, I believe, flaw in the drafting colors every one of these pages. They've added some accounts here and accounts there on debts that he has. We have no quibble with that. Against some of that I just got today, but I'll show you on page 3 of 17. Here, they're trying to do that's the exact squeeze. Rather than doing a percentage of the pension, they're trying to give a dollar amount based upon old numbers and not in conformance with your order. So here, if you reject that conceptualization of your order, most of these edits are going to go away. The only one that would be left, and I'll stop here. I know we're out of time, but they were saying that he should have 30 days to pay the judgments for attorney's fees and for unpaid spousal maintenance. And if not, that we would be able to bring quadros against his pension. That wasn't your order, but we would agree to that language. The only area of difference is that the court awarded attorney's fees, and we had proved up. My prior counsel was Miss Becky Beaver, and by stipulation, her fees at $30,000 were reasonable and necessary. But without explanation, they've excised out the award of the $30,000 fees for her, leaving only the $26,000 for myself. So we would ask that $30,000 for Miss Beavers, where they removed it, be brought back in to the order, and that their 70-30% conceptualization be rejected, and then most of these red lines will flow.
All right, so let me hear from you, Mr. Carroll, about these.
Thanks, Your Honor. And I don't know if Mr. Verdict could pull that back up.
Gladly. Sorry, Mr. Carroll.
In response to the attorney fees we were just discussing and the $30,000 $30,000 in previously paid attorney fees. First of all, the first we'd ever heard about that is when Mr. Verdict sent us this proposed decree. They were not mentioned in the hearing we had on March 8th, and he didn't prove those fees up. There was no evidence put on that there was a $30,000 previously paid in attorney fees to his office or Ms. Beavers. Ms. Monroe actually testified that Mr. Monroe paid Ms. Beavers' attorney fees on her behalf at the hearing. In response to the division, more broadly.
Hang on a second.
Okay.
All right, I do see in the transcript a statement where Mr. Carroll asked Ms. Monroe, would you agree with me that Mr. Monroe's paid over $30,000 in attorney's fees for you? And she says, yes, it was $31,796.12. So if he's already paid that, Mr. Verdict, I don't find that he needs to pay it again. He paid it community funds, is what it says.
He did. Those community funds were paid to her. Later in your transcript, I think is where we were dealing with the prove up of attorney's fees, including Miss Beavers. But as the judge stated, the evidence at trial was that she had paid $31,000 and some additional numbers through community funds.
Actually says that he had paid, Mr. Monroe had paid Miss Monroe's attorney's fees using community assets.
I believe that was the testimony, Your Honor. It was later in the hearing where, and again, my client is unable to afford the transcript, but my unaided recollection is that later in the hearing is where we proved up all attorney's fees, Mr. Carroll's, Miss Beavers, and myself.
So I do see where the question to her was, are you asking the court to confirm and order him to pay your attorney's fees outstanding to date to me of $26,000? And
yes.
Then are you asking the court to order him to pay the attorney's fees to Miss Beaver that you spent of $30,000? And she says yes, but it does sound like he had already paid them. So it was not my intent that he pay those again.
I understand, Your Honor.
All right. So back up to that language. If you'll put that back on the screen.
Yes, Your Honor.
I will accept the deletion of that $30,000 some odd dollars from the order.
Yes, Your Honor. And in terms of the division, Mr. Monroe accepts that, you did a 70-30 split of the community estate. The way we have drafted this decree in the attached spreadsheet is by looking at, the community estate as a whole, including assets and debts of the community. The decree that Mr. Verdict has put in front of you is actually, awarding much more than 70% of the estate to Ms. Monroe because it's not taking into account any of the community debt, only community assets. So she's getting 70% of all the assets and none of the debt of the community. So, she is in fact under the current draft Mr. Monroe's provide, or excuse me, Mr. Verdict's provided. She'll end up with much more than 70% of the community estate. And
Hang on
really
a
the
second.
only, okay.
My ruling says I am going to award the items requested by Mr. Verdict. That is 70% of the assets we know of in the community. I did not award the net assets or the assets less the liabilities. So that deletion, those changes that you made are not in conformity with my award. So
Here, Your Honor, I found the Miss Beaver's 30,000. So here I'm accepting that deletion.
okay.
And Mr. Carroll and I think have worked very well on drafting. The 70-30 language is so fundamental, we wouldn't be able to economically work that out in front of you. So with the court's guidance and leave, perhaps he and I can continue offline, and if required, come back at the end of your docket today if needed.
Yes, that's fine. I do think now that you know that it was my intention to split the assets 70-30 and not the debts 30, y'all should be able to work out the rest of the changes. So
I think
we are
we should.
here in
Mr.
the
I'm happy
Zook
to chime in
matter, Zook versus DeSimone, and I assume that you all want a record. Is that correct?
Yes, ma'am.
Then I will remind you all, you need to speak at a normal speed. Not your normal speed, Mr. Gilbreth, other people's normal speed. He speaks really fast, those of you who haven't heard. So that the court reporter can make a good record, and also to be real careful not to speak over one another, because on Zoom, we can't really hear all of what either person is saying if two people speak at once. So we're here on a motion to compel and motion to quash. I see the motion to quash was dated February 20th, and the motion to compel is dated February 22nd. Is that right?
Yes, ma'am.
I think so.
It sounds right. I would just request, if the other lawyers are okay with it, if I could go ahead with I don't have a dog in the hunt on this other motion. That's the motion to compel. Mine's the motion to quash. And if we could do that one first, if that's okay with everybody, then I can get out of here.
That's fine. Since that one was filed first, I was going to suggest that anyway. So
Thank you.
So Mr. Castling, go ahead.
Hello, Judge. Kemp Castling on behalf of Richard Minor. So the situation here is Miss Zook and Mr. DeSimone have a child between them. And what has prompted this situation now is Miss Zook has filed a motion to modify custody or possession schedule, claiming that Mr. DeSimone has engaged in some bad conduct in front of their child, so forth and so on. It's all set forth in her motion to modify. Where my client is, I would say not involved, but involved somewhat, is he is now dating Miss Zook. As the court is aware, all discovery, including depositions, are governed by Rule 192.3A that says you're entitled to discover non-privileged and relevant information relevant to a claim or defense. And you can't, if it's not admissible, that doesn't matter as long as it reasonably appears to be calculated to lead to the discovery of admissible evidence. So
Hang on, let me just stop and say, for any lawyers who are not here in the Zook matter and who don't plan to speak, even if you are here in that matter, but you don't plan to speak, if you'll just both mute yourself and turn off your camera, and also parties in another matter. If you'll turn off your camera, that's a whole lot fewer people for us to have to look at. Thank you.
Thanks, Your Honor. So the key thing is that the evidence or testimony you're seeking in the deposition has to be relevant. Now, the claims by Ms. Zook are that Mr. DeSimone has engaged in actions detrimental to the child. There is no allegation in her motion that says that Mr. Minor, my client, was ever present during any of these actions by Mr. DeSimone or these alleged actions. There's no allegation that my client has had any communications with the child to ask her if her dad acts bad or he does any of these things. Mr. Minor is not intending to testify at the hearing on Ms. Zook's motion to modify possession. And again, he's had no conversations with the child. So he hasn't witnessed anything. He hasn't seen anything done by Mr. DeSimone that would bring him into the realm of someone that they would want to talk to about, okay, what did you see? What did you hear from Mr. DeSimone? I assume Mrs. Zook is going to testify to the things that she can testify about, and I don't know whether the child will be allowed to testify or not, but that's not my fight. So they subpoenaed him a while back, and I filed the motion to quash, and it just kind of went away for a while, and then they subpoenaed him again, and I re-urged my motion to quash. So what's happened since the last time was Miss Zook was she filed a new amended pleading in her supplemental pleading or amended pleading, I can't remember which, but she now alleges that she was driving Mr. Minor's vehicle and she had taken it to a car wash, and someone at the car wash said, hey, when we were parking your car, something was rattling underneath the hood, and so we want to take a look at it. And so she let them take a look at it, and it appeared to be some sort of tracking device. She then drove the car again. Miss Zook, Mr. Minor was not with her during this incident. Miss Zook took the car to, I think, the dealership, and they confirmed, according to her pleadings, they confirmed that this device on Mr. Minor's vehicle was a tracking device. She then, again, according to her pleadings, went to her house and looked in her car and found a tracking device there as well. Mr. Minor was not with her when this happened. It's my understanding that these tracking devices have been turned over to the Cedar Park Police Department, and they are in the process of investigating it to determine who purchased the tracking devices and who downloaded the app that would allow you to track the vehicles that were in the tracking devices. Mr. Minor is not doing any of that. That's being done by the Cedar Park Police Department. So it seems to me that that's who they want to depose if they want to find out whatever they want to find out about these tracking devices. As I said, Mr. Minor is now dating Miss Zook, but he has no interest in being involved in her child custody fight with the dad of her daughter. And so it's our position that under Rule 192.3a, there is no pleading, claim, or defense for which Mr. Minor has any relevant testimony. And we're asking that the court quash the subpoena for his deposition.
All right. Thank you, Mr. Kessling. Mr. Gilbreth?
Yeah, I'll briefly respond and then turn it over to Ms. McCullough just to sort of help orient, because I represent Ms. Zook, and I think just because of the words they and this, it was a little hard for me to follow. It's actually, so we filed our petition to modify. Mom, we represent Mom, filed our petition to modify, and that's currently set for trial in May. While the suit was pending, kind of the current thing that the parties are focusing on, my client, Ms. Zook, discovered a GPS tracking device on her vehicle and on her boyfriend's, Mr. Minor's vehicle, right? Ms. Zook's position is, hey, Dad, Joseph DeSimone must have done this. There's an application for protective order. There's an ex parte protective order that was signed by Judge Mozzie. That's Mom's theory. I assume Ms. McCullough.
Slow down a bit, please. Just keep an eye on Miss Williamson. She's shaking her head, which means too fast.
I was looking more at Ms. McCullough to make sure I was saying everything, given the background correctly. My understanding,
nodding or shaking my head, so yeah.
So she approves by omission. I assume Mr. DeSimone's theory is that someone other than him put the GPS tracking devices on my client's car and Mr. Minor's car. I'll address that, kind of what we're looking for in our motion to compel that's related to that. As far as the deposition, it was actually Ms. McCullough's client, Mr. DeSimone, asking to depose my client's boyfriend. And we don't have an opinion on that. So I have something to say when it comes to our compel, but as far as the deposition, that's actually Ms. McCullough asking for the deposition on behalf of Joseph DeSimone, trying to get my client's boyfriend's deposition.
All right. And do you all intend to call your client's boyfriend at the trial?
I was not intending on calling him at the trial as I see the way it's oriented right now. Whether or not he's a person with relevant knowledge is Ms. McCullough's argument. But we were not planning on calling him.
All right. Thanks. Ms. McCullough.
And Your Honor, just to interject, he's not going to voluntarily appear.
Okay.
May I proceed, Your Honor?
You may.
This is a modification action. Mr. Minor, Mr. Casling's client, is the boyfriend of Ms. Zook, as he's already stated. It's just not true what Mr. Kasling has represented, that he hasn't been around the child or seen the child. Apparently, they're all in Cabo, Mexico right now. We received documents from them yesterday that showed that Mr. Minor purchased the tickets. It's going to be a contested modification, as well as the protective order, which was consolidated into the suit affecting the parent-child relationship. And just to give the court a little bit more context, the parties' order regarding the suit affecting was signed in February 15th of 2023. So we're talking about a suit that's just a little over a year old. In addition, part of that suit involved Ms. Zook making a claim that she was married to Mr. DeSimone, and that was denied. So just, I wanted you to have that background information. You know, the right to depose a party like Mr. Minor, I think, is apparent to most people who are in a family law case, whether he wants to be involved or not. He is involved with this family, and we do want to depose him.
On what
It's
issues?
not-
On what
on
issues?
what issue? On his relationship with Ms. Zook, on his observations of her parenting, of his interactions with the child, what things has he done for the child, on his the car that's at issue. One of the cars at issue is apparently a car that is leased by him but driven by Ms. Zook, and Mr. Gilbreth was correct in that we are taking a position our client didn't place those devices on the vehicle, so we would want to depose Mr. Minor about that as well. He began dating Ms. Zook and gave her a Lamborghini within weeks of them dating. So there's a lot that I think we have the right to explore in his deposition. I just don't think
I just want to know on what issues you think he has relevant information. So just saying that he's observed the mother and child, don't do it for me. I need to know.
possession and what, well, I'm sorry, Your Honor, let me let you finish.
No, I just want to know what specific issues, the specific issues that are relevant to the modification action that this witness should be deposed on.
Conservatorship and on possession and access.
So,
And also on the protective order.
and what information, if what Mr. Kasling said was true, which is Ms. Zook is the one who found the tracking devices on the two cars and took them to the dealership and took the devices to the Cedar Park Police Department, then what is it that Mr. Minor can add to any of that?
Did Mr. Minor place the devices on the vehicle?
So have you sent or attempted to get that information some way short of a deposition?
That information in particular, not yet.
All right. And then conservatorship, possession, and access, because he's spending time with the mother and the child?
Well, I think if you look at the factors, yes, Your Honor, and if you look at the factors that are in the family code, I think it's 154.123, the variety of issues that a court considers when they're making a decision about conservatorship, I think it falls squarely in with that as well.
All right. Thank you. You want to add anything, or is that the gist of your response?
Well, I think also his relationship with the child, I think that our client has expressed concerns about Mr. Minor's involvement with the child, and whether he's someone who would be appropriate to be around the child. And so considering the newness of the relationship and that he's now taken the child to Cabo San Lucas in Mexico, I think those also are pertinent areas of inquiry.
Has your client filed some sort of counterclaim? Are you seeking a different modification?
We're in the process of filing a counterclaim, a counter petition, Your Honor.
But as of right now, there isn't one on file?
No, but mom is seeking to change what is essentially a equal decision-making, equal periods of possession to, well, according to her yesterday, sole managing, and I guess also reducing his time with the child.
How old is the child?
She is in, boy, I'm sorry, Your Honor, I don't know the answer to that question. She's a young teenager.
Mr. Gilbreth?
Yes, ma'am. She's 13. She was born November 2010, so 13 and a half.
All right. Thank you. So, Mr. Castling.
Your Honor, I think Ms. McCullough misunderstood my argument. I said that Mr. Minor has not been a witness to any of the actions and things that Ms. Zook says that Mr. DeSimone has done that is the basis for her request to modify. And nothing that Ms. McCullough said has changed that. Yes, he's been around the kid because he's dating the mother, but there's no, and furthermore, I think you hit the nail on the head when you said, is there any pleading that would implicate Mr. Minor? There is none. There's no claim anywhere that would implicate Mr. Minor's knowledge of the things that Ms. Zook says. Ms. Zook's lawyers have filed a motion to modify. And in that motion, they have set forth certain claims that they believe will have the judge modify the current possession and custody arrangement. The things that they have said Mr. DeSimone has done, Mr. Minor hasn't seen any of those things. And there's no allegation anywhere that he has. So it's our position that they don't have a basis to take his deposition. He's not going to come to the hearing voluntarily unless somebody subpoenas him. He doesn't want to be a part of this. He's dating the mother, and that's it. And I don't think they have satisfied their burden under Rule 92.3A that this is relevant testimony that they seek to get from him.
Mr. Gilbreth, add anything?
No, ma'am, other than, well, so then yes, we'll commit. I mean, obviously that we are not calling him as a witness. If he was being called by us, we would list him as a person of relevant knowledge on our disclosures, which I just double checked that we have not. If that changes, then I think that would change the makeup of the situation. But we stand by what we said before, which is we're not intending on calling him.
May I respond, Your Honor?
You may, briefly.
The pleading, of course, the modification is a broad pleading, and it's not just regarding the facts that are attached in an affidavit that really had no bearing on the case. It's much broader than that. She's seeking to make modifications, and she amended that pleading just yesterday. So the fact that, he may not have been present at some incident that she refers to in an affidavit doesn't have anything to do with it. I also think their failure to list him as a person of knowledge of relevant facts. Anybody could then block a person from deposing someone by not listing them as a person with knowledge of relevant facts. It doesn't mean that he does not have knowledge of relevant facts. And in part, I believe that we get to depose him so that we can find out what information that he has regarding the mother and the child, their relationship, his relationship with the child, and so forth.
All right. I want to go ahead and hear the other matter that's set for today before I make a ruling. So, Mr. Kathleen, you need not stay if you don't want to be part of this other part of the hearing. We'll let you know our ruling when we make it.
I'll go on mute and take my picture off, but I'll listen.
All right, fair enough. All right, so the other motion is the motion to compel.
Yes, ma'am.
Dated 222. All right, Mr. Gilbreth, you may proceed on that.
I think we can narrow down to just two categories. One is earning records, and the other is essentially bank statements and credit card statements. On earning records, we had, and I'm not sure if this is even in dispute, we had asked for earning records. Dad had objected, Mr. DeSimone had objected. At the time, we were just seeking to change conservatorship and possession access. I do think earning records are still relevant to that because it's a Hawley v. Adams factor for the court to consider the relative financial resources and makeup of the households. But more than that, since then we amended our petition to include a request to change in child support. And given that we're asking for a change in child support, then I don't think Ms. McCullough would argue that earning records aren't relevant. It's actually required by the family code. that there be at least 2 years worth of tax returns. And so there's earning records. And we amended yesterday. Again, I think that they're relevant all the way back to when we filed our motion, but I don't know how anybody could argue if we're asking to change child support that tax returns are not relevant. So hopefully that's not a big dispute.
Let me just ask, did you just ask for 2 years or did you ask for more?
Let me see. That's a good question. I don't have that at my fingertips.
It looks to me the bank statements at least, what I see is January 1, 2023 to present, and the others are January 1, 2023 to present.
Right. So really it'd just be 1 year, looking at our motion, which makes sense actually given to where the prior order was. So it'd be 1 year's worth of earning records, which I think would largely be Mr. DeSimone's 2023 tax return. And if he hasn't filed, then documents reflecting income, K1s, those sorts of things. The purpose of the bank statements, I mean, I think with the child support modification for a self-employed individual, that bank statements and credit card receipts are arguably relevant. But to be frank, the purpose of that goes down to this GPS tracking device, right? It's there was a GPS tracking device placed on my client's vehicle, on her boyfriend's vehicle. Mr. DeSimone last week, there was an arrest warrant issued for his arrest, and he has been arrested for that. He's out, but there are criminal charges pending on that. And we've written and said, and he's frankly been a little coy so far on whether or not he placed it. If you review the file, for example, when we asked for an ex parte protective order, which was granted by Judge Mazzi, Mr. DeSimone, the morning of the hearing, filed his own unsworn declaration and said, actually, I've read this affidavit where Ms. Zook says she discovered a GPS device on her vehicle. Hey guys, I just checked my vehicle and somebody placed a GPS device on my vehicle. But he doesn't specifically say, I didn't do that, or I haven't purchased a GPS device. And we've simply asked and said, we need credit card statements and bank statements. And because we know the company that produced the GPS tracking device. I've written Ms. McCullough, this is uploaded to the box. We've even offered to narrow it rather than just say, turn over all your bank statements. We said, well, what if because we all know what we're looking for specifically, whether or not there was a purchase of this GPS tracking device, which would be reflected in a credit card statement, a bank statement, either in Mr. DeSimone's name or one of his business's name. So if you guys think that's too broad, we'll even offer up an in-camera inspection, obviously request an in-camera inspection on that. You guys can redact except for, these items. Obviously, I would prefer a third party doing it, so Ms. McCullough's not put in the position of having to make that judgment call if it's on the line. But that's what we're looking for, and we've done everything we can to try to narrow it to those line items in the bank statements. The request for production is broad. We've offered, again, the exhibits are in box to try to narrow it, and we haven't been able to reach an agreement on narrowing it and trying to get this tailored to the information. I guess last I'll say, if I was Mr. DeSimone, I'd want to produce this to say it couldn't be me, guys, because we've looked at my bank statements, my credit card statements, and there's no purchase of a GPS tracking device by this company in those statements. We have not been able to resolve those issues. I think the rest of the issues me and Ms. McCullough have and or will work through. And to the extent that my request is granted, obviously I would request that any request for attorney's fees just be reserved to final trial.
All right, Ms. McCullough.
Thank you, Your Honor. Again, I want to go back to some context on this. Their suit was filed in October 31st of 23, and the discovery was served in December of 23, with our responses being due in January. And of course, I understand we have an obligation to supplement our discovery, but this discovery was served in the modification before the protective order was consolidated with it, which happened on February 22nd. And I'm sorry, the order consolidating was signed on February 28th. And today it's, March 20th. So the requests and the motion to compel were related directly to what you can get in their modification, which at the time that all of this was teed up only related to a modification. And in a modification of conservatorship and a modification of possession, I disagree with Mr. Gilbreth that a wholesale access to Mr. DeSimone's personal and his business banking records would be relevant is a stretch even under the Holly versus Adams factors. A request for securities and brokerage accounts that is not relevant in a conservatorship or possession and access lawsuit, nor are retirement and other employment benefits. And the other, I think there's some 1, 2, 3, 4, 5, 6, 9 or 10 items that are listed out in their modification, in their, motion to compel, just simply don't relate to the modification. And so we would ask that you deny those. The fact that they filed a new case yesterday that includes a request for child support, that would mean we were under a continuing obligation to supplement, but it doesn't mean that we should be compelled to do so. Their motion would be premature on the issues, the items that would be related to the child support. And because they are asking for attorney's fees, I would not want to have you make an order that says he's required to produce documents that would not have been produced if this were just the way the suit was standing at the time they filed their motion to compel. I think that would put us in a position of then having to make an argument again at trial where you will most likely not be the judge on whether my client made objections that were worthy of a sanction of attorney's fees. So we would ask that you deny their motion to compel, and if need be, if we don't comply, I mean, both Mr. Kirker and I are aware of what our obligations are when there's a child support suit filed now. If we don't comply with the discovery request, that would be a different motion to compel, but not this one. It would be really an advisory opinion and not, since the case was not even filed at the time that the motion to compel was filed. So, and also in terms of what Mr. Gilbreth said about efforts to narrow it, I'm not aware of any of the things that he stated on the in his argument to the court about limitations that they would put. That could be because he discussed that with Mr. Kirker and not with me. But I haven't seen any email or anything like that where they make the kind of offers that they're talking about. To me, with the standing of the case as it is regarding the tracking devices, the easiest way to find out who purchased the tracking device would be to subpoena the company, and not to have Mr. DeSimone have to produce all of his bank record. I mean, it would start extending into everything, right? Well, what about your Venmo account? Well, what about a Zelle account? Well, what about your Amazon orders? What about all your bank records, all your credit card statements? I think it would be an impossible task for us to go through and have them have access to all that personal financial information, when it would be much simpler and more direct to simply ask the company that sold the device who purchased it.
All right, thank you. Mr. Gilbert.
I think I hear us saying somewhat we're on the same page on earning fees, and we had written Ms. McCullough this morning, because I do think that that's relevant even before I modified. I hear her when she says, look, now there's no dispute, so I don't want my client compelled, because we're saying we understand that now that there's not even an argument one way or the other. And I'm fine with that representation, right? If she says we understand now that there's really not we don't even have to go down that path about whether or not it's a Holly v. Adams situation where I get it regardless, then I think it would be more appropriate to just say we can withdraw or reserve those issues. It goes down to what we need court intervention on is the GPS tracking devices. And we did reach out, for example, yesterday asking if they had suggestions. I think Ms. McCullough's suggestion was, for example, my client will issue a sworn statement that says that he didn't purchase any. Well, I appreciate that. as family lawyers, we all know that people sometimes lie, which is why we have production. So I'm not looking for even if I think I could argue that I'm entitled to it, I'm not looking for unredacted bank statements or every single bank statement. I'm looking for, and I've suggested a third party look at it. I'm suggesting a third party look at it, but if Ms. McCullough is comfortable saying they look at the financial records and they can redact except for the purchases of GPS tracking devices or the purchases from this company that did it. I'm trying to narrow it because I understand the objection. I don't agree with it. I think I'm entitled to all of it, but I think we should be able to come to a mechanism of narrowing it. I didn't hear a strong objection other than it's burdensome, and that we may ask for more.
All right. So is it true that you're not putting up a fight on the earnings? You just want to have your 30 days from when they added those claims, Ms. McCullough?
I can't imagine that Mr. Kirker or I would object to producing some earning records in that regard, Your Honor. We know what needs to be produced under the family code.
All right, so then I do think it's appropriate to reserve the issues on that. Then on the redaction, on the spending that would show up on bank statements or credit card statements. I do believe that it is appropriate for him to ask for any evidence that would show a purchase of this device or of anything from the company that made or sold these devices.
Wouldn't that then be the request to be made, Your Honor, and not just a wholesale request for banking records and so forth?
Well, he's just agreed to narrow it to that during this hearing, correct, Mr. Gilbreth?
Yes, ma'am. There's a broad request, which is why we make broad requests. So I don't have to reissue discovery, and I've offered a narrow and will continue. And so it would fall under that request, but narrowed as the court stated. And
I
I'm certain
I don't object to that.
Okay.
we're saying the
if
same
that-
thing. We'll
yeah.
come up with an
Okay.
agreement on the way to do that.
So what that sounds like to me is that any bank statements, if they show a purchase to this company or for the tracking device, credit card statements, if they show, is that correct? What you're asking, Mr. Gilbreth?
That is, and we can come up with a mechanism, if it's okay if me and Ms. McCullough are just talking, if we could come up with a mechanism where if there's none, then Mr. DeSimone says, writes a statement that says,
Yeah.
I've looked at these, I've looked at all my credit cards, my bank statements, my business credit cards, my business bank statements, and there's none.
Yes, I don't object to that.
All right, so it doesn't sound like y'all need an order from me on that. You've got an agreement on the record about that. We will reflect in the docket notes that you all reached an agreement on the issues on the motion to compel.
Well, except that I would ask the court to, at this time, deny 3, 4, 6 would be under advisement, 10 would be denied, 11 would be denied, 17 would be denied, 19 would be part of the agreement, and 20 would be reserved.
So I'm going to let y'all look at those together and make sure that you are in agreement on that. I want to take a quick break anyway. So, Mr. Gilbreth, how long do you need to look at those and see if you agree with what she just said?
Well, I guess my response to that is I can argue why all of those are relevant and should be produced. I've chosen not to spend my client's time and money since we got what I needed on that. But if we're going to go in and say it's denied, or if something comes up in this case, or I can't proceed, I would say I can formally withdraw them on anything else in my motion. I can formally withdraw on the record to be reserved at a different time. And then if Ms. McCullough can fuss it final and say, well, I had to go to a hearing on that, just like I'll say when I testify to fees, look how reasonable I was. And we can talk about that at final trial.
I agree with that. And I think that would be the way for us to resolve this and not have to then then come back. I think that makes sense.
All right. Do you want to confer for a few minutes on which ones those are going to be?
I think we're there. I think we
I
have
agree.
what we need from the court.
All right. Which brings me back to Mr. Casling's motion to quash. I agree that if Ms. McCullough's client files a counterclaim for a modification that somehow implicates issues about the mother's care of the child or the mother's having Mr. Minor around the child, that would become relevant, but that modification action hasn't been filed yet. I don't see that any of his testimony is likely to lead to the discovery of relevant evidence based on the pleadings as they are now. And that being the case, I'm going to grant the motion to quash now, which let me just add, is a ruling that may need, well, you may need to file a new subpoena for this witness, and you may have to fight this battle based on whatever the pleadings are later, but those pleadings aren't before this court now. So the motion to quash is granted.
Thank you, Your Honor. I'll submit an order
Great, thank you.
that would be excused, or at
Yes.
least I'll be excused.
You may. All of you are welcome to be excused.
Your Honor, I heard you say that you needed a break. I'm happy to give you one.
I do need a break. I'm going to pull up the file.
Mr. Granger. Your audio is terrible. I don't know if it's only terrible for me, but you may want to figure something out about that because it's very difficult to understand you.
I hear the robot voice as well.
Yes, it's bad. All right. Why don't we go ahead and take about a 15-minute break? It's almost 3:15, so let's be back around 3:30.
And before you go, is this better?
Yes.
Much better.
Okay.
Thank
Thank
you.
you for letting me know. I saw you shaking your head. I was like, "Whoa, I haven't done anything yet."
Sometimes it's on autopilot. I can't control it. So
Okay. See you in 15.
thank you.
And I've looked briefly at the Koenig matter. Is that how I pronounce it?
Yes.
And I see the motion for continuance that was filed on March 6th and the motion for electronic appearance that was filed on March 5th. And those are both yours, Mr. Granger.
Yes, Your Honor.
So you may proceed.
Thank you, Your Honor. I suppose it may be the primary issue is that we have not been able to communicate with our client at all, really, until the middle of this month. So just recently. The reasons for that are still not entirely clear to us. We are under the impression that we're facing a competency matter and some mental health issues at this time. And we are hopeful that the court will allow us about 60 days to address those issues and take an appropriate path if there truly is one. Nevertheless, notwithstanding potential mental health issues of our client, the fact that we have been unable to speak with her since last year really has dampened our ability to effectively represent her. So we would request a continuance of 60 days for those reasons. Additionally, as far as the motion for electronic appearance, Ms. Koenig lives in Minnesota. She is not a woman of means. It would be a financial burden for her to have to arrive in Texas to attend a hearing. Our motion does include next week's setting. I would request that if the court grants the continuance that we allow the next hearing or the continued hearing to be done virtually.
All right. I understand. It's y'all are the petitioner in this matter,
Yes, Your Honor.
and I take it there are children. Where do the children live?
They live with the father. I believe he's in Pflugerville. Is that right, Mr. Talavera?
I think it's actually Georgetown. I think he's he was in Pflugerville, but he had to move a little bit as part
Gotcha.
of.
There's only one child at this point. One of them aged out during the pendency of this case, and that child is 10, I believe.
All right. I understand. Let me hear from you, Mr. Talavera.
I'm going to try to go as slow as possible.
The reporter appreciates that.
I have a bad history. So there are two children that originally started the subject of the suit. That's me now 19 years old, and Joseph, they call him Joe or Joe Jr., who's 10 years old now. And originally this action was brought by Miss Koenig, where she had, back in 2022, she had alleged an ex parte protective order, domestic violence allegations, accused my client of all sorts of things, essentially. We had a hearing
Mr.
on all
Talavera?
of those issues.
Mr. Talavera, we had a little hang up on your audio. So not sure what that's about, but I just wanted to alert you if that happens again, we might need you to try to do something with your audio. It just
Okay,
kind of
will do.
slowed for a second there and dragged.
All right. So initially, part of the issue is that this case was started almost, I mean, at this point, we're going on 2 years that this has been filed. And this was started by Miss Koenig with multiple allegations. Those were found to, the protective order was denied. My client was granted primary custody of the children, but Miss Koenig was at no point required to pay child support. At some point in this litigation, and let me be very clear, we don't know when, Miss Koenig moved away from the area. Mr. And I was gonna say Mr. Bledsoe, but Mr. Granger, he's indicated that she's in Minnesota. We don't actually believe that. We don't know where she's at. We believe at some point she went to Minnesota. Then we believe at some point she went to California, then maybe to Alabama or Kentucky. And so at this point, Your Honor, my client has been the primary caretaker for all of their children, without support, without any sort of possession, and without any finality to this case. We initially asked for dates on January 9th for a final trial. Then me and Mr. Bledsoe spoke on January 17th, and I said, please get us a response by January 22nd. We emailed again on January 22nd, asking for dates, and then we set it and noticed it on January 25th for a date, a minimum of 45 days out, so as to not violate any rules when it's not an agreed setting. We've had that setting, and the issues that I see have been sort of ever present. These are not new issues. Her moving around, her sort of behavior are not new issues. So in our situation is that, and I understand their position that, they may have some difficulty in dealing with a client who is unavailable, but at the same time, I think Mr. Koenig is entitled to some resolution in this matter and the ability to ask at least for some support during the upon finalization of this case.
Does he have any reason to believe that Ms. Koenig is employed?
No.
All right. Does he have any reason to believe that what Mr. Granger is concerned about, that is that she may be subject to some mental illness, does he have reason to believe that's not true?
No. He believes that she may be subject to or has been in a institution in the last year, to the best of our knowledge. And this is all obviously, Your Honor, secondhand information that he has received from the maternal grandmother in this suit. He has no direct knowledge, but I can tell you that that wasn't a surprise.
All right.
Oh, and sorry to add to all of that. If she wants to appear electronically, we don't really have an issue with that, given whatever distance she may be at.
All right. So I'm going to say there's been an agreement for an electronic appearance. Actually, we don't really have the equipment to allow for a partially remote hybrid kind of hearing where it's a lawyer or a party who's not present. So we generally, if it's just a witness who's not going to be on very long and who doesn't have to be on camera, or everybody doesn't have to see that person, that's not a problem. But when it's a party or a lawyer, we strongly prefer that we do a fully remote hearing instead of partially. So do you have any objection to that we would just do a Zoom hearing?
No, Your Honor.
Mr. Granger, is that okay?
That would be fine, Your Honor.
Okay. So I'm going to grant the request for remote or electronic appearance, but make it clear that the parties have agreed to a Zoom trial. All right, then as far as the continuance is concerned, I do see that Mr. Bledsoe has signed an unsworn declaration. While I have some empathy for your client, Mr. Talavera, in wanting finality, I do think under the circumstances that that Mr. Granger and Mr. Bledsoe should have additional time to try and be able to effectively communicate with their client and prepare for trial. So I'm going to grant the continuance. But because of the request that this really does need to happen sooner than later for the benefit of all the parties, but particularly to the father who's raising this child, I'm going to say that well, let me just ask, how long are you asking for, Mr. Granger?
We asked for 60 days, Your Honor.
So I am going to grant the 60 days continuance. I am going to ask that the two of you get together and take a look at the trial calendar and figure out when in approximately 60 days you're most likely to be reached for whatever length of trial y'all agree is necessary. And then if you want me to sign the order, I can do it, or we can just make a docket note that the 60-day continuance was granted and a Zoom trial has been agreed to, and then let y'all contact the court administrator's office.
I was going to say, I trust the docket notes. So I'm fine with that. I can have an order sent in here in 30 minutes or so, but that works too.
Mr. Talavera, up to you. You want an order? I will
I
make
would.
a note that if I just make a docket note, the note will say that this continuance was granted by request of petitioner.
And Your Honor, I just want to be, I guess I kind of want to be clear. I know it's semantics at this point because we're set for trial on March 27th. But I guess, so you're granting 60 days from today's date, right?
Correct.
Okay, not 60 days from the original trial date.
So I'm granting 60 days from today's date, but like I say, if it turns out that exactly 60 days will get you at the bottom of a long docket, but if you go out 63 days, you're more likely to get reached. I expect y'all to work that out.
I don't think, yeah, I understand that. My desire is to get reached instead of waiting around.
All right. All right. Well, thank you. Y'all are excused. And if you do want an order, you're welcome to get Mr. Granger. The two of you can sign agree to form and send it in. Otherwise, we will make that docket note.
Thank
All
you.
right.
Thank you.
Y'all are excused.
Mr. Talavera.
Yes.
Miss Williamson, were you talking?
I was just being silly when you said they were excused. I said, except for Mr. Talavera.
I heard his name, but I didn't hear the except for. Yes, yes, I do. This
All
is the
right,
other
we're
case.
here
that-
on a
that
motion
is-
to enter. It looks like that was filed on February 16th. And it's based on an October 26, 2023 MSA. So, Ms. Sheridan, it's your motion.
Oh, actually, I thought it was Mr. Talavera's motion.
It is.
Okay.
Oh, sorry, I read it wrong. Then you represent Miss Fuller.
Yes, Your Honor.
Mr. Talavera, you represent Miss Fuller.
Yes.
Got it. All right, thank you. You may proceed.
Thank you. So Your Honor, as you stated, this MSA, we're going on 6 months at this point of this MSA being entered, and we have one singular issue on the entry, but then I am going to request some evidence on the fees issue here. So first, I'd like to point out what the on the entry itself, the singular issue comes down to whether or not a judgment as part of the decree should include language for late payment of the amount ordered. So essentially in the decree, what we have is that Mr. Fuller is awarded the main asset, I think all parties would agree, the main asset of the home is awarded to Mr. Fuller, that being the house. As a form of an equalization payment in this case, Mr. Fuller is required to make a payment by a date certain to Miss Fuller in order to sort of effectuate the transfer of that property as an equalization payment. What I have done in my draft and the singular issue before the court is I have gone to the Office of the Consumer Credit Commission website, which has them sort of maximum allowable post-judgment interest rate, and I have put that amount in here at 8.5% compounded annually, which is pretty typical for the way that I draft. That is the singular agreement. And Judge, you may say, well, why is that important? And why is the entry of this so important? And my second argument is that we believe that under the mediated settlement agreement, Ms. Sheridan's firm was supposed to draft this agreement. And the evidence will show that there were multiple emails, multiple follow-ups, multiple attempts to get this resolved. Because as a matter of fact, Mr. Fuller owed $270,363, $270,363.50. That amount was to be paid within 90 days of the mediated settlement agreement, which occurred on October 26th, 2023. By my computation of time, that amount was actually due on January 24th, 2024. So most of the time when we're arguing about late entry or delay in the final decree, people aren't affected as much as they are in this case. In this case, we have a very significant and serious effect on my client, who has yet to receive a single penny of the $270,000 that is owed to her as a result of the MSA. And my inability to have a drafted order and the delay is causing significant, not just financial harm, but financial distress for the primary parent of 2 children in this case. So to me, Your Honor, that's to parcel this out, the one disagreement we have is the interest rate. I took it from the OCC. The second part of my argument is I believe I should be awarded fees for the delay and for having to do all of this sort of when I eventually had to draft an order 4 months after the fact, when in reality the MSA had that responsibility on Mrs. Sheridan. And again, my argument there is most judges will say, well, if there's no harm, no foul. But my argument against that is that there is actual harm in this case, and it's in the tune of $270,000 that has yet to be unpaid.
All right, thank you. I understand. Ms. Sheridan.
Yes, a couple of comments. Number one, the mediated settlement agreement specifically said all of these issues were to be arbitrated. We went to, I know, one arbitration. I don't think that Mr. Fuller should be subject to fees or anything else when we were having legitimate disputes about the form of the order. Another thing, I mean, I'm happy for the court to make a determination today, but technically under the MSA, it's supposed to be arbitrated. I will tell you in one of the arbitrations, that it was with Mr. Salinas. And when we did the arbitration, the disputed items, on several occasions, he said, such and such wasn't in the MSA, so I'm not going to allow that in the draft. There is nothing in the MSA that provides for interest. I have had the $270,000 in my trust account for, I'm not even sure, over a month, if not longer. But it wouldn't be prudent to pay it until we finally got an agreed order. We had asked, as far as delay, we had asked Mr. Talavera and his client for arbitration several times, and they refused for over 2 months. But we finally got there, got most things resolved. We had other issues that just got resolved, I think last week, regarding personal items. So fees and interest do not seem appropriate. I can have, well, it's late in the day, so I don't know how long the bank would take, but I've had that money in my trust account for a tremendous amount of time. It's not that we're refusing to pay it. We just wanted a final decree entered before we paid it, as you can probably understand.
Let me ask you, is that in a separate account that bears?
Yeah, it's in my trust account.
Sorry, one at a time. Does that, I know that for short periods of time, you're allowed to commingle money in your trust account that doesn't bear interest. But I know that if you're holding money in an amount like this, that's sometimes placed in a separate account or subject to separate accounting with interest bearing. So I'm trying to figure out which this is.
Well, we have the check and we have a separate flagged account. That's the way I usually handle things when we take in house proceeds or something like that, to make sure that it's flagged so it doesn't get commingled with, retainers and other client monies.
So does that account bear interest?
Yes, because it's the IOLTA account and all of them bear interest.
So the question, my understanding, and forgive me if I'm wrong, my understanding is that for the most part, where you have small amounts of money from lots of clients, you can commingle them and put them in an IOLTA account, and where none of those would really give rise to enough interest to benefit anybody, that money gets siphoned off and sent to the Equal Access to Justice Foundation. But for the money that might actually amount to something, that money doesn't necessarily go to the Equal Access to Justice Foundation. So that's what I'm trying to determine. Is that an interest-bearing account that goes to the Equal Access to Justice Foundation, or is it in one where the interest can be paid to the person whose money it is?
I would have to check on Judge Soifer. And I'm happy to do so. I just want to get, now that we finally, hopefully after today, have a final decree, I do want to get his client her money, because we've had it for so long. Because part of the payment was that because she's remained in the home until it was paid, and even though he was awarded the home, she was supposed to pay the mortgage until this all got resolved. But I don't think either party should be penalized for legitimate disputes about the form of an order. But I am happy to have my staff contact the bank and see if there's been any interest accumulated on that, and whether it is going to go to Access to Justice, or if we could just add that to Ms. Fuller's payment. But our biggest complaint is that there was nothing about this incredibly high interest rate on this money that was deposited with my office, but we were still in legitimate disputes about the form of the order and we still had this last issue to resolve, you know?
All right, thank you. You want to add anything, Mr. Talavera?
Yes, Your Honor, I would like to add some of the exhibits to kind of clarify our position in this case. So I would offer what is respondents 10, which is going to be the Texas Office of the Consumer Credit Commission. I've uploaded that to the box if I need to. That's the current interest rate. There's a publishing by the Texas Office of Consumer Credit Commission that says the maximum current post-judgment interest rate for March of 2024 is at 8.5%. That's the one I've included. That at the time of my drafting, it was 8.5% at that time as well. But I've just included the most current interest rate. I would also like to sort of offer the communications between the parties, and then I'll call myself on the attorney's fees that we've incurred since the mediated settlement agreement. But I would like to offer respondents 5 through 9, which indicates sort of, well, actually, respondents 2 through 9 indicate our attempts to settle this matter. Too fast, Ms. Williamson? So, Your Honor, I would ask that you take judicial notice of the file.
All right, well, I do take judicial notice of the court's file. I note there's 21 items in it. Ms. Sheridan, do you have any objection to respondents 10?
No, I do not.
What about respondents 2 through 9?
No.
All right, so respondents 2 through 10 are all admitted. All right. I would like to know whether there is interest that the bank can tell us how much that is and what rate it accrued at. How quickly do you think you can find that out for us?
I guess it depends on who I can get a hold of at the bank, but as soon as we get off this hearing, I will get my staff on it immediately.
All right. That'll give me some time to review these communications, which I think is appropriate for me to do.
Sure.
And, I will tell you, I am not inclined to award fees if the communication makes it clear that there were legitimate disputes and that it wasn't all one party's being unreasonable. So I do want to look at that. As far as the interest, I am concerned, Mr. Talavera, about your client not having access to the funds that were supposed to have been paid now almost 2 months ago. But then again, it goes back to whether or not it appears there were legitimate disputes as opposed to some kind of nefarious plan to hold back the money from your client. So let me review the file and those exhibits that I've just admitted. If I change my mind and I do find that there was not a legitimate dispute or there's reason for me to award attorney's fees, Ms. Sheridan, would you have any objection if Mr. Talavera provides those by submission?
I have no objection.
All right. So instead of you doing that, if I'm not going to award them, that'll give you the right to do it later if I do award them. Is that okay with you, Mr. Talavera?
Yes, Your Honor. Can I at least testify to the Anderson factors? I understand that there's the Roar Moose versus Ventures requires me to provide my invoices, as I understand it, unredacted and with the ability to state what those activities are, which are my respondents 11 and respondents 12. But I believe for the record, I would still need to at the very least testify just as to who I am, the reasonableness of my fees, which I believe were the Anderson factors that used to be the only requirement prior to the Roar Moose hearing. I don't know if.
So because I'm not sure that I'm gonna award them, can I just ask that you put those in a unsworn declaration or an affidavit if I decide that I am going to award them.
That's fine, Your Honor. Yes.
All right. So I'm going to conditionally admit your invoices, which are, tell me again, the,
Respondents 11, which is the invoices, and then respondents 12 shows a record of activities as well.
any objection?
No, ma'am.
All right. So we'll just say our 11 and 12 are admitted, and I will consider them if I determine that attorney's fees should be awarded. And I will at that time give you an opportunity to provide me with an unsworn declaration or an affidavit proving up the various factors that need to be proved in addition to the information in the invoices. All right.
And I apologize, but Your Honor, I want to be very clear. You're reserving the post-judgment interest rate issue. You're reserving until Ms. Sheridan can, I guess, determine whether or not that is being held in an account that bears interest. Is that correct?
Yes.
Okay, I just want to be clear.
All right. We will get you all a decision as soon as we hear back from Ms. Sheridan, and I've had an opportunity to review these exhibits in the file. All right.
Your Honor.
Thank y'all. Y'all are excused.
Thank you.